Hi friend, welcome to the Company Law Education and Appeal series. Today we are discussing Mumbai ROC Adjudication Order for the violation of Section 149 subsection 1, that is the non-appointment of women director in a company. This is the case in the matter of the Krishna Solve Chem Limited and order pronounced on 23rd October 2023. Let's see the case detail. Company having a registered office at Mumbai, and as per the section 149, every company shall have board of director consisting of individual and director, and shall have minimum number of 3 director in public company, 2 directors in private company, and 1 director in OPC, and maximum 15 director. And proviso said that a company may appoint more than 15 director after passing a special resolution. And further, second proviso says that class or classes of company which as prescribed shall have at least one woman director. And Rule 3 of Companies Appointment and Qualification of Director, Rule 2014, says that every listed company, every other public company having paid up share capital 100 crore or more, or turnover of 300 crore rupee or more, provided that a company which has been incorporated under this act, then shall comply this provision within 6 months from the date of its incorporation, and provided further that any intermittent vacancy of women directors shall be filled up by the board at the earliest but not later than immediate next board meeting or 3 months from the date of such vacancy, whichever is the later. And explanation says that paid up share capital or turnover, as the case may be, as on the last date of the latest audited financial statement, shall be taken into account. And facts of the case that the paid up share capital as on the 31st March 2022, that is the 4.45 crore, and turnover is the 320 crore 45 lakh 26,321, and company is required to appoint a woman director based on the threshold stated above, but it failed to do so. ROC has issued so-called notice for violation of this section, and company has replied that reproduce here for your reference, what that is the uh, financial describing is financial position. Companies engaged into the business of the chemical trading, in which the net profit margin is generally very marginal as compared to the turnover of goods in an organization. An audit of the financial statement for financial 21-22 was concluded around mid-June 2022, by when the company and its officer become aware about the final number of the turnover, net profit, and other financial indicators. So in the company, since the turnover of the company was marginally exceeded, trigger the limit of 300 crore for having the woman director on the board of the company, it was not possible for the company and its officer, before finalization of the financial number, to understand the requirement of woman director as per the provision of section 149 subsection 1 of the act. And being aware of the provision, women director on the board uh, of director, the company and the officer have taken efforts of engaging with the few candidates to get appointed on the board, but due to one or other reason, the appointment was not yet made, but efforts were going on to identify the suitable candidate for appointing as women director. Further, section 149 subsection 2 said that per se is this subsection is not applicable in the present case, but the intent of the law makers was to provide a period of 1 year to comply the provision, which get attracted due to enactment of a new law, and hence we request you to consider the same also in our case, wherein the applicability of having a woman director by the company was made aware in mid-June 2022, and reasonable time must be given in order to identify any suitable person, which must have in mind the degree of responsibility and duty towards the stakeholder in accordance with the act. The company and officer would like to place on your record, company is fully compliant and has zero tolerance towards applicable statutory compliance, and follow high standard of the compliance system mechanism in order to achieve the desired outcome of the company and various stakeholders, including the government authorities. And hence penalty under section 172, if a company is default in complying with any provision of this chapter and with no specific penalty or punishment is provided, then company and every officer of the company who is in default shall be liable to a penalty of 50,000, and in case of continuing failure with a further penalty of 500 rupees for each day during which such failure continues, subject to maximum of 3 lakh rupees in case of company and 1 lakh rupees in case of official who in default. And a whole-time director being authorized representative attended the hearing and submitted there were no mens rea and default was committed due to unavoidable circumstances. There no malified intention. Restricted reasonable time must be given to the company to comply with the provision. Company is in its letter submitted further reply informing that this office that women director has been appointed as additional non-executive independent women director on 20th May 2023, and that has she had further been appointed as non-executive independent women director with effect from 12th June 2023. Presiding officer submitted that the company in its reply dated 8 April 2020 stated that it has become aware applicability of provision regarding appointment of women director in mid-June 2022, yet the company failed to appoint a woman director. Despite knowing its statutory mandate, a period of 1 year as requested by the company is an unreasonable amount of time to find suitable candidate and should not be granted. And uh, as per the analysis of financial that as on date of 31st March 2020, company paid up capital is 4.45 crore and turnover more than 300 crore, and company is required to appoint a woman director based on the threshold as stated above, but it failed to do so. And further, the uh, company ROC has in its order uh, imposed penalty on the company, that is the on the company 1,85,500 on the company, and 1 lakh is each on its of official who in default. And here the first default penalty 50,000, default continues 270 days. It is a total penalty imposed 1,85,000 and maximum penalty 3 lakh, that is the here 1,85,000 on the company. And uh, three director who is officer on default is 1 lakh each on the director, that is the maximum penalty imposed, and total penalty imposed here is 4.85 lakh. And period of violation of provision of section 149 is from 1st July 2022 till 28th March 2020. There is delay or is 270 days. As the signatory details available on the MCA period, I will mention individual where official in default during the period of violation. And penalty is commensurate with the aforesaid failure committed by every officer of the company, and notices shall pay the said amount, and proof of payment will produce for verification within 30 days of receipt of this order. Thank you so much for watching this update.